Okay, welcome everyone. Thanks for joining us this morning. My name is Andrea DeLulio and I'm president of the UB Law Alumni Association's Gold Group. Thank you for attending today's CLE presentation, Cybersecurity Trends and Emerging Issues. This is in a series of many virtual programs that the Law Alumni Association and the Gold Group are hosting as a service for our alumni and law students. If you're interested in attending other upcoming webinars and CLEs, you can register on the UB Law School website. You can also listen to past CLEs and other webinar recordings at no charge on our new alumni education webpage, also located on the law school's website. Finally, I'd like to thank the Gold Group sponsors who have helped underwrite the costs associated with these events: Chicago Title, Council Press, Equitable Advisors, Jack W. Hunt and Associates, and Precision Resolution and Paramount Settlement Planning. Now, a few administrative points. You will be muted during the course of the presentation. If you have a question at any time, please use the chat room and send your question directly to me, and we will try to address all questions cumulatively at the end of the presentation. At some point during the course of the CLE, the course code will be announced, and I will also place it in the chat room in case you miss it. But please be sure to catch it, as you'll need it to put on your attorney verification form that can be located on the registration page from this CLE program. This form is required to issue you your CLE credit, and please also return the program evaluation form with your attorney verification. It is now my great pleasure to introduce our speaker, Jennifer Bekich. Jen is a member of the class of 2007 and a partner with the law firm of Bekich PLLC. Jen is a former tech business owner and is now a nationally recognized data breach attorney. For her practice, Jen counsels clients in the areas of breach response and mitigation, data security, information technology and privacy law, and business growth. Jen also develops data protection and crisis plans and IT policies for her clients, including counseling clients on compliance with the EU's General Data Protection Regulation. In 2018, 2019, and 2020, Jen was recognized as one of the top 30 data breach attorneys in the United States by Cybersecurity Docket. Jen is the only person in upstate New York to ever receive this honor. She is also a certified information privacy professional in the United States, in Europe, and has been certified by the International Association of Privacy Professionals. I could continue on with Jen's many other qualifications and recognitions. However, I'm sure you'd much rather hear her speak. So without further ado, I give you Jen Bekich.
Thank you. Thanks, Andrea. Really appreciate those nice, warm remarks. And also, I thank the sponsors for this event. Without them, we can't do events like these. And I'm a proud UB alum. And it's really nice to see some familiar faces on today's Zoom meeting here. And really look forward to answering any questions that anyone has at the end of the presentation. I'll be sure to leave a lot of room for that. Okay, well, with that, we'll go ahead and get started. As Andrea mentioned, we're talking about cybersecurity trends and emerging issues. A lot's been going on in the last few years, especially the last decade, but just even in the last few years, a lot of changes. So I'm going to try to start at the beginning so that we level set, because I know everybody on this call has varying levels of experience with cybersecurity and technology issues. And then sometimes people think that they understand cybersecurity issues, but may have missed a few things along the way. So I always like to kind of start, right at the beginning. Since Andrea did a really nice job talking about myself and the firm, I won't go into detail about that. I will say that we do have many UB alum on our team of attorneys. We have offices from California to New York, and we're really proud to help support UB. And thanks again for all the comments about me, and everyone's got access to these slides. So first, we're going to start with the legal landscape. Why? We're lawyers. We always start with the law. So we're going to start with the law. We're going to do a legal landscape about data security and privacy issues. Then I'm going to talk a little bit about some of the threats that we're seeing. As Andrea mentioned, our firm handles a lot of incident response. Being nationally recognized for our work we're very proud of that, especially being from upstate New York, to have that national recognition with firms that are really in other major cities like New York City, DC, and others. we see a lot of incidents that impact the world. And so I want to talk a little bit about some of those threats. One, as you continue to grow your own practice, but also so that your firm can think about what sort of threats they may have. Our law firm represents a lot of law firms in these types of issues. So we'll talk a little bit about that. And then we can't talk about cybersecurity to an audience of lawyers without addressing some of the ethical obligations. And then I'll provide some best practices. So let's start at the beginning. There's two substantive areas. There's privacy and security. And people often just roll this off the tongue like it's one thing and it's not. Privacy is really the concept of leave me alone. This is my information. Let me control what you do with my personal information. That's the concept of privacy. Security, on the other hand, is keeping information safe from unauthorized users. They're two separate disciplines. Sometimes they complement each other. Sometimes they conflict with one another. The example I give is sometimes an organization, to help enforce security of their systems, may have to trample, arguably, a little bit on some of the privacy rights or potential privacy rights of individuals in the organization. For example, IT may need to look through an employee's email inbox to see if there's fraudulent emails in there or suspicious activity. The employee may not like that, but to help enforce security for the organization, they've got to trample a little bit on some potential privacy rights. So let's talk about data security first. So in the United States, we don't have an overarching federal data security law. Instead, we have a variety of federal statutes that address data security issues like GLBA or HIPAA. So these laws usually govern an industry, financial sector, or health providers, or the types of data that they handle, financial information or health information. As of, I think it was August of 2018, all 50 states have data breach laws. So they're all a little different. Many of them look and feel and smell the same, but they've got some nuances. But all 50 states have a data breach law that says what an organization should do if they have a data breach. And what a data breach is defined under the law. And now we're seeing states adding data security requirements into their laws. So the data breach laws themselves don't talk about data security. It just says if you have a security event, you have to notify potentially impacted persons and regulators. But now states are adding some data security requirements. And the two states that really lead the charge, if you will, on data security and privacy issues are California and New York. And so let's talk a little bit about New York. There's two regulations or two laws that I'm sure everyone's probably heard of by now. One is the Department of Financial Services Cybersecurity Regulation. And that provides that organizations that are in the finance, banking, or insurance industries have certain security safeguards and controls in place, certain governance in place, certain policies in place to monitor third-party vendors. This regulation was sort of a first of its kind and had tremendous ripple effects. But again, it only applies if you or anyone in your business is operating under banking, finance, or insurance laws. Now, sometimes law firms are implicated in this. And so being comfortable and aware of what the DFS Cyber Reg is important because it does put some obligations on the organization, if it is a covered entity, to have certain security protocols in place. The next one that I'm sure everyone's also heard of is the SHIELD Act. And the SHIELD Act did two things. It expanded what's New York's data breach law. So when you do have to report a data breach in New York, it expanded the definition of what's personally identifiable information that would need to be reported. And then it also required any organization that's handling New York resident data, so even if they're outside of New York, but if they're handling New York resident data, to have certain security protocols in place. So here's a quick slide on how the definition of private information in New York has been expanded. Most data breach laws protect information like social security number, driver's license number, account number, but we're starting to see the states add things like biometric information and email address in combination with some sort of passcode or security question. If one of these items is the subject of a data breach, you most likely have to report that data breach to potentially impacted persons and to regulators. Now, these are the data security requirements that the SHIELD Act imposes on any organization handling New York resident data. And these, if I've been in this space for a really long time, these aren't anything new, if you will. Administrative, technical, and physical controls. You'll hear this a lot in data security regulations. Organizations need to have reasonable administrative safeguards, technical safeguards, and physical safeguards. So what are administrative safeguards? These are your policies. This is your training. This is identifying people in your organization that are going to coordinate your security program, make sure it's working, update it regularly, especially if the data situation changes or there's new risks to the organization. If they notice things like that, they're going to adjust their security program based on those new circumstances. So our firm, for example, helps a lot of law firms and other clients come up with these administrative safeguards. Myself and many others on our team are former technologists or technology business owners. So we keep in mind the technical standards. I'm just going through the legal standards right now and drafting these policies. Technical safeguards. These are the ones that everyone usually pushes off to the IT department. Have a great firewall. Is there multi-factor authentication? Do we have tools that will notice anomalies that are happening on our network? These are our technical safeguards. And then physical safeguards. This is the one everyone seems to forget. You could have all the great firewalls in the world and extra security, but if anyone can walk into your law firm and access your server room, if you have on-premise systems, they could just walk out with it. So we need to make sure that there's physical safeguards in place. Does your law firm or your business have people escorted if they come into your firm or your office, or can they just roam around? Do they have name tags? What sort of steps are you taking, to protect your systems? Security cameras, fire prevention tools. There's a lot of things that you would want to think about as far as physical safeguards. This even also includes shredding. We always talk about electronic data, but also think about that physical data, right? Things that have been printed out, records that have been stored in the numerous banker boxes that I'm sure all of us have. We need to think about those things just as much as the electronic information. Again, so in summary, the SHIELD Act broadens the definition of what constitutes a breach. In its definition of what's protected information, but also to include that it's not just if information is accessed or is acquired, but also if it's been accessed. And I'll explain this a little bit more. Most data breach laws in the United States have made a distinguished between whether a breach involves the access to information or the acquisition of information. So acquisition, you've got to have some actor come in and take that data and it leaves the building. And access means maybe just seeing it or viewing it. Obviously, those standards are quite different. And you have to really look at every data breach law to understand if this is an access case or an acquisition case when you're evaluating the breach. And we never use the B word. I always get frustrated when people are, we've had a breach. Hold on, you've had an incident. We don't know if it's a breach under the law. Let's take a step back and make sure that we understand what's going on, because we get so many phone calls of people panicking that the sky's falling, and it's a ransomware we've seen before. It's an event we've seen before, and even though it's saying it's encrypted and doing all these bad things, it really isn't. And so, we really like to understand what's going on before we call it a breach and make some early preliminary conclusion without enough facts that there was acquisition or access. I will note the SHIELD Act does provide an exception for inadvertent disclosure of private information. And there is this exception if it's not likely to result in the misuse of information. And we've all seen these situations. Let's say your employee accidentally emails out a list of other employees' social security numbers to another law firm. And that law firm receives the email and says, oh, this was a mistake. I shouldn't have received it, and can attest that they've permanently deleted it. They didn't even open it, or they didn't review it. It's been purged from their systems. It's not sitting on backup. That might be an instance where we say, it was an inadvertent disclosure, but it's not likely to result in any misuse of information because we know who received it and they've attested that it's been removed. There's also some exceptions to the SHIELD Act. If you're a small business, which is defined as fewer than 50 employees and less than $3 million in gross annual revenue for the last 3 years. In that case, it's always this reasonableness standard. What's appropriate safeguards for the size and complexity of the business? So that's the SHIELD Act, very high level summary. We could do, and I have done entire presentations on the SHIELD Act, but I just wanted, to mention that and note that other states have data security provisions, to be aware of them and, to consider them when you're counseling with your clients. Now, we're also starting to see data security requirements sneak into data privacy laws like the CCPA. So let's talk a little bit about the cybersecurity threat landscape. So this is a great sort of image of all the different threats that an organization has. I'm not a big fan of presentations where they say things like, it's not if, it's when, and this doomsday, it's going to happen, and everyone should be scared, and employees are horrible, and employees are bad. I've seen these phishing emails. I've seen these attacks. They are incredibly sophisticated. Some of the smartest people I know have fallen victim to them. Users are not always the problem. I think they're one of your best defense if you have proper training. So even though employees and the users usually get a lot of blame for these attacks because they're the ones that click on something, again, they can be your best defense. But what are we seeing from a threat landscape? Obviously, a lot of phishing is happening. We do still see quite a number of ransomware attacks. I will say our clients that we work with that are prepared have never had to pay a ransom. We've been able to work around it. We have a lot of experience in this space. Another issue that we see very common is email compromises where there's no multi-factor authentication on email. And for those of you that aren't familiar with multi-factor authentication, that's where instead of going onto your computer and just typing in a password, you actually have to take a second step. So maybe something hits your phone, a text that provides you a code that you have to put in, or there's an alert that hits your phone that you have to authenticate on your phone that you are who you are in addition to that password. We do still see bad employees, whether they're intentionally bad or just make some errors, but we do see disgruntled employees taking information. They might set up competing businesses. They might just be out to get the organization, but we do still see a lot of that happening. Few other things that I wanted to mention that aren't even on this slide that we've seen as of recently are vishing attacks, vishing with a V. It's not so much now that you just get an email and there's a link and you click on it. But what's happening is the bad actors are actually calling you on the phone and legitimizing this email. So they might call in advance and say, hey, Joe, I just wanted to let you know that, we think that you would be a great speaker at this event. I'm going to send you an email. Just click the link and, provide some information. And then we would like to set it up so that you could speak at this event. So Joe's going to think, well, okay, this is a phone call. I'm expecting this email, and they click on the link without doing any independent authentication of who that is. This makes it even more complicated to prevent against these risks. Your users are going to be more likely to click on those links when it's accompanied by a phone call. I like playing with people when they try to do these kinds of things and try to understand them a little bit more. But these incidents are quite sophisticated. They'll set up 1-800 numbers. They'll have call centers. They'll create LinkedIn pages. They'll create web pages. They'll take a lot of sophisticated steps, but those steps are actually really easy to do. I used to own a web design company. It doesn't take much to throw up a website and some pictures and a phone number. So be careful of the phishing attacks. We're definitely seeing a lot more of those. And make your clients aware of that. The other thing that we're seeing a lot of right now is data shaming. So it's not enough to launch ransomware and say, pay me money for me to unencrypt your information. Now the bad actors are saying, pay me money, or else I'm going to go post all over social media that I have your data and I'm about to sell it on the dark web. This data shaming brings in a whole nother level of PR issues. Having worked on a lot of these, really understanding who these actors are, and will help legitimize whether they really will act on this threat or not. So again, a lot of sophistication in this space is needed. You know, if you get a call from a client, it's your first data incident that you're responding to, please associate, and I'll get into the ethical rules in a minute on this. You have to associate with people that do this all the time and are familiar with these kinds of threats, because one misstep, one improper negotiation step could ruin everything for the organization. So you have to be really careful with that. But the data shaming is definitely, we're seeing more and more of that. And social engineering is still a very common threat. So what's social engineering? And I'll just use Andrea as an example. Let's pretend Andrea loves Disney and she posts all over her website how much, you know, she loves, what's a Disney character? Mickey Mouse. So Mickey Mouse this, Mickey Mouse that, and if maybe you are, Andrea, I don't know, but everything's about Mickey Mouse. Well, we can probably assume her password involves Mickey Mouse. This happens all the time, right? We have to think about the things that we're posting online and making sure that our passwords don't reflect what those are. I always tell people, come up with a passphrase. Some people like to do things, you know, full sentences. You know, long passwords are one, easier to remember, and they're sometimes very much harder to breach. So social engineering, you know, be careful of what you're posting online, because again, they can use that information to help perpetrate a sophisticated phishing email. Most times these bad actors are in your system for a while. They see how you respond to emails, right? Maybe you always do an XOXO, Jen, or you know, you don't end things with a period, or you always use dashes in your salutation, whatever it might be. They'll catch on to those little things. So it will help them in putting together a really legitimate phishing threat. And again, I just posted some other information about other potential threats that we see. So again, fraudulent emails that attempt to steal your data. This is what you have to be careful of and talk to your employees. And I think you just have to be really honest with them. You know, I tell my staff, I will never ask you to buy me iTunes gift cards. That's a phishing threat. I don't know if anyone's seen this one yet, but it's out there. So I just tell my staff, I will never ask you to buy me iTunes gift cards. Another one, you'll get an email from a manager or a president. Are you in today? Can you help me with something, right? They wanna see if you bite and respond. So just be careful. I'm never gonna send you that email. I know when you're in, or I'll just send you an email, but and have some more specific things. So, you know, I like to just be really honest with people about the actual threat that I'm seeing so that they're better educated. But things that we also tell everyone to keep aware of is be very careful about any email where they're asking you to confirm an account, asking you to log in or provide a password, or to click on links. Again, if you receive an email that has a bunch of links on it and you weren't expecting it, you know, and Andrea, sorry, I'm keep using you as an example, but if Andrea sent me an email about this presentation, I didn't know anything about it, instead of clicking on it, I'd probably call her from the number that I have for her firm to reach her, not the phone number that's in the actual email itself, but the email for her firm, and call her to legitimize, hey, did you send me that email? And I'm going to be honest with you, nowadays, no one is ever going to balk about you confirming who an email came from. Everyone gets it. These threats are real. We're seeing increased threats during COVID. And these are just some really great best practices and steps. Yes, it does slow things down, but we all can take that extra minute and make that phone call. Check the sender's email address. It's so easy to spoof email addresses. And no one really looks at the actual email address because it's usually just the person's name in the email. Sometimes you don't always see the full email address depending on what email platform you're using. So there might be an extra L that's very difficult to see if you're quickly skimming an email, but always checking that email address. Look at what time the email came from. Why is someone sending you an email at 3 in the morning? That might be odd for that particular vendor. So malware and ransomware, we talked about. This continues to be really the biggest risk that organizations are facing. Ransomware is when a actor, and you don't have to be sophisticated or have a lot of technical skills to deploy ransomware. Anyone can do it. And actually there's a lot of young people that are doing this. Just there are hackers growing up in the community, right? They're just trying to see what they can do and how far they can go. But these are still probably the biggest threats that we're seeing is businesses not being prepared for a ransomware attack. And it's actually something that's pretty easy to prepare against. There's some security steps and controls that they can put in place. There's things that they can do to help prepare themselves so that if they do get hit with a ransomware, they can still stand back up again. And obviously everyone saw, I think it was on October 1st, OFAC just released additional guidance. Everyone always says, don't pay ransomware. We don't want to encourage, these types of attacks and payments to bad actors. And now, discussion about the potential risk of sanctions and doing that sort of activity. But some organizations are in a tough spot. If they're not fully prepared and they're hit with ransomware, that might be their only chance to stand back up their business. And we understand that, especially small businesses. It can cause incredible havoc. All right, so let's talk about ethics. So we know that all industries, including the legal industry, face challenges concerning data security and privacy. And this presentation, as I mentioned, is really about data security and not the privacy landscape. I'm happy to do a presentation on privacy at a later time. We have to keep up on all the laws and regulations that may be applicable. Like I said, law firms may be subject to the DFS cyber reg. Not only that, but we also have to think about our ethical obligations as well. So what are those? There's 3 rules that I really want to talk about today: the competency rule, the duty of confidentiality, and supervising non-lawyers or subordinate lawyers, which is rule 5.3. So let's talk about the first rule. Lawyers must keep abreast of the benefits and risks associated with technology that the lawyer uses. So in this remote world, lawyers may be jumping on any platform to try to have, meetings like this, virtual meetings. They need to take steps to understand what that platform is, go to their privacy policy, understand what they're doing with data. Are they by default recording the presentation? Maybe you're talking about client confidences in that meeting. Are there additional safeguards that you can deploy to help make it secure? UB here was great. The Gold Group, making sure that they admitted people into the meeting instead of an automatic admission, having passwords, sending out individual links to meetings, really understanding what are the additional security controls that you can deploy to make the technology that you're using more secure. And the thing that I always hear in response to this is, well, I don't know anything about technology. How can I possibly, evaluate some of the tools that we're using when I don't even understand it? What is the cloud? Where is the cloud? Is that in heaven somewhere? I don't even understand what that is, right? And I understand that, but this is where you need to associate yourself with sophisticated technology counsel that can help make sure that the vendors that you're using are going to be held to the standard that they're required to keep that information safe and secure. So the ethical rules require us to have this technological competence. And if you don't have it, associate yourself with someone who does. Understand the technology that you're using to protect firm data. I've been in these presentations and I've had people raise their hand saying, I know my firm doesn't do this, or I know my firm doesn't do that. Talk to your managing partner, talk to other people on your team, speak up if you're not comfortable with something. There are ethical rules about this, and maybe you understand the technology better than some of your partners. I think they would be happy to hear from that. So don't be afraid to share concerns so that people can act upon them. Also, I find sometimes that organizations, especially ones that are really large, sometimes with people at the top, if you will, don't interact with a lot of the tools that some of the other staff do on a day-to-day basis, so they can't appreciate some of those risks until somebody brings it up. in addition to really understanding all of the rules that are applicable, we need to make sure that we're investigating our vendors on a regular basis. So it's not good enough to just sign up a vendor, sign an MSA or, a click-through agreement online, and then just never audit or review them again. On a periodic basis, at least annually, if you can, issue them an information security questionnaire. Check to see if they're still honoring what they said they would do in the contract as far as data security and privacy. Are they sharing your information with third parties? Has the data situation changed? Or maybe you don't use that vendor anymore. How many times have you gone back to look at those vendors you don't use anymore? Did you ever ask them to delete all of your data? Did you ask them to return it? To get some sort of declaration from them that they've permanently purged it? There's lots of hanging vendors, right? Hanging around that organizations still may not use, but are still holding on to information. So a periodic review of vendors and their security practices is a really great step. Rule 1.6, the confidentiality of information. A lawyer shall not knowingly reveal confidential information unless there's consent or authorization to do so. And a lawyer shall make reasonable efforts to prevent the inadvertent or unauthorized disclosure of information that's protected under attorney-client privilege. So then the question is, what are reasonable efforts, right? As lawyers, what do we need to do? And again, I think this is where you can look at laws like the SHIELD Act for guidance. You can look at some of the ethical opinions for guidance. What is reasonable? And we're going to go into some of these in a minute. Talking a little bit more about Rule 1.6, paragraph C imposes 3 related obligations. It requires a lawyer to make reasonable efforts to safeguard confidential information against unauthorized access by third parties, right? So those are those bad actors that are coming in, deploying ransomware and malware in your systems, against inadvertent or unauthorized disclosure by the lawyer. This is that oops, that example I gave earlier, where someone accidentally emails an Excel sheet with all the other employees' social security numbers, or other persons who are participating in the representation of the client or are otherwise under the lawyer's supervision. So this could be a paralegal. This could be a third-party vendor that you hire to assist. You've got to be able to make sure that you're taking reasonable efforts to safeguard that confidential information if it's used by them. So what's reasonableness? Comment 16 provides some factors to be considered. The sensitivity of the information. Look, if you've got every copy of the Wall Street Journal on PDF on your saved as PDF on your desktop, who cares, right? If someone gets access to that, you don't have an obligation, to report to any individual because it doesn't contain any individual sensitive information. So really look at what's the sensitivity of the data that you're protecting. What's the likelihood of disclosure if additional safeguards are not employed? Is there going to be a high chance that if you don't add a firewall or you don't add multi-factor authentication, that this information is going to be shared somewhere? The cost of employing additional safeguards and the difficulty of implementing them. Cost very rarely comes up in evaluating reasonableness, but I love that it shows up here because it is true. For a small business, the cost of even hiring an IT person or purchasing some of these tools can be really expensive. And that's a factor that has to be considered as well. But there also are a lot of low-cost opportunities out there. I remember looking back at a presentation I did many years ago, and I had concerns about people moving to the cloud because at the time, a lot of the providers didn't have a lot of security protocols in place. But now there's so many great third parties that provide cloud services that are such a low cost. They can provide more safeguards sometimes than the small business can do on their own. It's actually cheaper to use a provider, and you're actually going to get more security. There's another piece of this, though, the difficulty of implementing the safeguards. How many steps do we need to take, right? Do we have to have the server locked in a safe, locked in a room, surrounded by guards, surrounded by a moat, surrounded by, how many steps do we really need to take? And then is it going to make it so difficult that we can't work, right? Is it going to be so many challenges that we can't even operate our business to do so? This has to be balanced with all these other factors. And the last one is the extent to which the safeguards adversely affect the lawyer's ability to represent clients, which I mentioned, right? We want to make sure that people can still operate their business. So these are what the ethical rules consider to be reasonable. But again, I would strongly suggest that you really look at some of the other laws out there that address data security and those administrative, technical, and physical safeguards. Those are really key. You're going to see those appear in lots of laws and lots of industry standards, especially around technology. So as I mentioned before, this doesn't just apply to data, it also includes paper files. We're all taking things home. We don't want our associates to take all of the sensitive files, put them in their car, run into the Wegmans, their car gets broken into, right? It's the nightmare. I remember actually in downtown Buffalo finding a lawyer's briefcase. I left it on top of his car, drove off, the briefcase open, and all of his pleadings and notes were all over the street. I actually picked them all up on the street, identified who the lawyer was, and got it back to him. But the paper we need to keep secure, as best as we can, just like the electronic data.
Hey, Jen, before you jump into the next slide, I just want to announce the course code. It is threats, and I will also put that into the chat for everyone. Sorry.
No, that's great. Again, as lawyers, we always have to assess when the circumstances warrant special precautions that need to be made. Think about what practice you're in and the information that you may have that would be considered interesting to others, right? We've seen very, very large law firms that have been subject to data incidents and really sensitive information about mergers and acquisitions or about celebrities, right, have become available. Those are things that should be considered when you're thinking about the reasonableness of the security controls that you have in place. Lastly, Rule 5.3, responsibility over non-lawyers. And again, this is where we're really thinking about, paralegal staff, administrative staff, but also those third-party vendors that you may use. For example, in e-discovery, you're giving those e-discovery vendors a lot of data. Who's actually checking to see if that e-discovery vendor is reputable for data security and privacy? Those are things that you're going to have to review with them when you're contemplating and keeping in mind these ethical obligations. So comment 3 to Rule 5.3 states that you can use, non-lawyers to assist you in rendering legal advice. And again, I gave an example of an e-discovery vendor. Maybe use other vendors to store client information. Maybe they help you with your billing or timekeeping, whatever it might be. But when you're using them, here's our reasonableness standard. We have to make those reasonable efforts to ensure that the services are provided in a manner that's compatible with the professional obligations of the lawyer and the firm. So what are those reasonable efforts? Which things should we be looking at? The education, experience, and reputation of the non-lawyer. There's a lot of vendors out there. I'll say when I was in this practice, and as we all know, as lawyers, you're only as good as the cases that you get. And I got a lot of data incident matters very early on, many years ago, because of my tech background. And there's very few lawyers that really understand technology. And having owned technology business before, I got a lot of cases. There weren't a lot of vendors out, many years ago in this space like there is now. There is an oversaturation of vendors that are trying to provide cybersecurity services. And unfortunately, they've been the reason why we've seen a lot of incidents. They're not reputable. They don't have the education and experience. An example I give is I met a very lovely person at a very large event for data security and privacy issues. And she was talking about her business, and she said all the right things and she seemed really qualified. I did my due diligence afterwards and really researched her, and turned up that a year prior to her opening up this cybersecurity firm, she was working at a grocery store, and she had been working at a grocery store for the 10 years prior to that. Had no cybersecurity background, work experience, or anything like that, but was just entering the market. And look, everyone has to start somewhere, but when you're holding on to your data, your client's data, I don't know if this is when you want to give someone like that a shot, right? That might not be the instance where you want to share that information. Try to use people that are experienced. Another thing that I see right now is there's so many people running out and getting these CIPP certifications. And look, I have two. So I'm not, saying that they're not good, but getting a CIPP certification does not mean that you know data security and privacy. Experience means everything. They don't teach you how to respond to incidents. They don't teach you all of the data security laws and nuances and all the things that come into play in incident response. So just be very careful. I had an accountant who came up to me the other day and said, I want to take the CIPPE so that I can provide legal advice about the GDPR. And I was like, well, that's the unauthorized practice of law. You can't really do that. But again, those certifications aren't going to teach you about the ins and outs and the workings of the GDPR. So just be careful, just don't look at a certification on its own, really look at the reputation and experience of that vendor. Consider the nature of the services involved, the terms of the arrangements concerning the protection of client information. We see so many contracts where people think that they've held the vendor to certain data security obligations, and they haven't. They don't meet the standards. They don't meet the technical requirements. They don't understand the technology that's at play and what vulnerabilities can arise from that. So again, really associating yourself with people that really can understand those terms. And there's a lot of them. This is a very fast moving space. The laws and cases are changing on a daily basis. So, making sure that you have those right contractual terms are critical. The legal and ethical environments in which the services will be performed, that's really important. Canada's privacy laws are very different from the US, and we know the GDPR is different from the US. So there's a lot of different things that have to be considered, especially when it concerns data transfers and things like that. And then, of course, the sensitivity of the information and how much the client will be supervising the work. So how do you do this? Again, you really just can't outsource your competence. You really got to take some steps to appreciate what's going on, but you should associate yourself with people that are experienced so that you can help carry out your ethical responsibilities. I provided in the materials a couple ethical decisions. I won't go into detail in this presentation because I want to leave time for questions, but it talks about, it is permissible to use backup tapes. It is permissible to use cloud providers. You can do all of these things. You just have to take those reasonable steps to protect that information. So I did provide a number of ethics opinions. If you guys have any questions about those, please, reach out to me. I've worked with a number of law firms on data incidents that they've suffered and have helped walk them through some of their ethical obligations. So to sum things up, I just wanted to talk about some best practices. I know I've talked about a lot of different things today, but I just wanted to mention just a couple of great best practices. One is good password hygiene. Don't have the same password, obviously, for all your accounts, or, it's Mickey Mouse 1, and then it's Mickey Mouse 2, and then it's Mickey Mouse 3, you're just changing a new number at the end. Passphrases are really great. Monitor your emails, report things to IT, create a culture of reporting incidents or potential incidents, or I saw the spam email, maybe others are getting it. Transmit data securely. I keep seeing all of these unencrypted little thumb drives. And this isn't my line, but someone had said once, thumb drives are the cockroaches of technology. They're in the drawers, they're in the floor, they're in the corners, right? You find one in the back shelf, they're everywhere. If you're going to be transmitting sensitive information, really use encrypted devices. They're not that much more expensive and they're really easy to use. Be careful if you're using platforms to transmit data, different websites. I know a lot of people use things like Dropbox or others. I'm not saying you can't use those. You need to evaluate what security protocols you're putting in place, who are the recipients, and what safeguards that tool actually has. Destroyed data. We got into this, I think, because of Zuba Lake decisions that we're just going to keep everything that we have, right? We're going to keep everything. It's easy and cheap to store data, but now we have too much of it. Record retention policies are critical. Get rid of that data that you don't need anymore, because I'll tell you, when there is a breach, it just is more information that you may have to report under. And when I see organizations taking a really long time to stand back up again, it's because they've had so much data and so many legacy systems that we have to try to restore. And then obviously report incidents. We get so many phone calls from people that just, maybe started off by working with another trusted advisor that doesn't understand the space, and they missed deadlines to report, blew past them by significant amounts of time. Report incidents, escalate things. They're quick calls, and it's so much better to know early on what the risks might be instead of trying to backtrack later. From working at home, secure your home workspace. Everyone loves to take these pictures of their Zoom meetings with everyone's faces, but then I see everything on your desk. I see your client's notes. I see what system you're using. I see the other software and platforms you're using on your computer, and they're taking these pictures and they're posting them on social media. Don't do that. Tell your staff, don't do that. It happens all the time. And really be careful. Using your own personal hotspot off your phone is really easy to do. Having a secure connection at home, not jumping on free Wi-Fis. We've seen people at conferences, we'll set up like a Wi-Fi that's called I'm a Hacker, and people will jump on it. They'll jump on it. It's unbelievable. Be very careful of hotel Wi-Fis. Those are so easy to spoof. I'm not trying to scare everyone, but there's just a lot of bad things that are out there. So, take that measure twice, cut one approach. Just be really careful. And I always say, if it's hard, security is probably working, right? If it's hard for you to log in and requires multiple steps, that's actually a good thing. So don't be afraid to take those extra steps to try to secure your platform. And I'll take some questions. Before I do, this is my legal disclaimer, right? This is not legal advice for any specific matter. If you have an incident, they obviously have to be evaluated on a case-by-case basis. There's lots of things an organization can do to help protect itself, but I'm obviously happy to answer any questions. You can follow me on LinkedIn or go to our website, but I post a lot of content about cybersecurity as well. But with that, Andrea, happy to answer any questions that may have come in, or if you have any.
Sure, thank you so much, Jen. I do have one question, and if anyone else has any questions, feel free to shoot them over to me now while Jen's addressing this first one. What suggestions do you have for a 1L with prior technical experience seeking to go into cyber law? Given that UB doesn't have a specific track for that specialization, are there any courses that you might recommend that they take?
Yeah, it's a really great question. And again, anyone who's on this call, my cell phone number is, please text or call me. I'm more than happy to, help you as you emerge in your legal career. Congratulations. Yeah, I know when I was in law school, there weren't technology classes, and, I think people said, well, take an IP class, but IP isn't IT. So, I think that some of the things that you can do is the CIPP certifications are great from a privacy standpoint. From a security standpoint, really familiarizing yourself with a lot of the different standards like NIST and what they require. I would suggest, following different kind of leading sort of vendors and firms out there that provide active blogs and content are really great. So you can kind of stay up to date on what's going on. Our website has an interactive map for data security and privacy laws, so that might be something you might want to dabble in. But there's lots of different courses that you can take through a lot of different universities, even at undergrad levels or sort of online courses. I love AI. I love working with my clients on AI technologies. I'm taking an AI class right now. I think that you should always continue to learn. It's not sort of a one and done. So overall, sign up for blogs, newsletters, just get a lot of alerts. It's a great way to learn, especially on cutting edge new issues. Look for certifications. That might be an opportunity to further, refine things. And then internships are great. So good luck with your legal career. And again, happy to answer any questions you may have after this presentation.
We also have a question regarding whether you recommend any online password managers.
I always get this one. There was one that had an incident. I think that, one day we will see them have an incident because of what they hold. And I only say that not because I think any of them are doing a bad job, but, our own government with, arguably unlimited resources have had incidents, right? Some of the largest companies in the world have had incidents despite, unlimited budgets and security teams. So, I think that if the alternative is you to have weak passwords, the alternative is for you to write down your passwords, then I would suggest one of those tools. There's some really good ones out there. I try not to give any recommendations on specific ones, but I think that that's definitely a good practice if it's going to avoid you, writing down passwords or using weak passwords.
Next question is, could you just speak a little bit more about cybersecurity vendors and what types of questions should people be asking when evaluating them?
Yeah, great question. So one of the best things to do is, to really look, obviously online at that vendor to really understand, what their privacy policy says, what sort of practices they engage in as far as sharing information with third parties. Are they certified? Do they have a SOC certification, for example? Some of those things will show that the organization has taken steps for good security. Depending on what laws you're personally subject to, your client subject to, those would need to be passed down to any third-party vendor that's handling information. I always want to make sure that in my third-party agreements, I'm also addressing appropriate steps if there is an incident, because so many people now rely on third parties to maintain their information. If there is a data incident that occurs on their end, you still have the legal obligation to report. So you got to be able to work with this third-party vendor while they're going through an incident. So really talking about what happens during an incident, what information they're going to share with you, and how prompt they're going to do that so that you can respond appropriately is another piece that's critical. But really understanding, I would really start with the laws that are the organization is subject to make sure that you're passing down those obligations, and research those vendors. Have they been having a lot of complaints? Are there lawsuits against them concerning their practices? Do some due diligence into who those vendors are. Because like I said, it's just overly saturated right now. And it makes it very difficult because, companies are looking at an organization that's telling them to make recommendations because that's what they sell, right? For us, we don't sell any products. So when we're providing recommendations to clients, we're coming up with an overarching plan for them. We're not trying to sell them services thereafter. So, really understand their motivation behind, what their recommendations are.
Next question is, how have you seen the cybersecurity landscape change since COVID? Has there been an increase in threats? Has there been new strategies? What should people be looking out for?
Yeah, we definitely have seen an incredible uptick during COVID, and a few things happened. There's just a lot of organizations that were never prepared to do remote, and so there was a lot of vulnerabilities in people using home devices or alternative kind of work environments that weren't secure. And then there were just a tremendous amount of phishing emails concerning local or regional updates that people are interested in, right? So if you got an email saying there's been an uptick in your community or your school district, oh my goodness, and people click because they're just looking for information about COVID. So definitely a lot of COVID phishing emails that came through. So yes, we've seen an uptick. And I think another reason why that also happened is, IT teams definitely have been very busy in letting their workforce move to a distributed workforce. And so they've just been a little bit distracted. And I think some of that has caused them, to maybe not, not look at data security issues, but it's a lot to do, right? Especially if you only have one or two people on your IT team.
So with respect to phishing emails, we see those a lot. It comes from likely the managing partner if you're at a firm saying, are you in? There's an urgent matter. There isn't necessarily a link to click. What happens if you inadvertently respond to that email before realizing it's phishing? What's the risk in that response?
Yeah, I mean, if you respond and yes, I'm in, right? Then that's usually a follow-up of, can you do something like buy iTunes cards, right? Or can you share something? Or I need money immediately wired into this account. I'm out of the office, right? That's when once you respond, then the actor knows that they've sort of got your attention and that you've sort of believed that it's legitimate. So then they'll follow up with sort of a next step. If you just respond and then don't take any further action, so be it. But those are the things you'd want to look out for, is what that follow-up email looks like. It's a good question.
All right, well, we don't have any other questions. So I'd just like to thank you again, Jen, for your time and insights. You will be receiving more information about our future CLEs. Our next one is scheduled for November 18th, and it's titled Federal Trials During the COVID-19 Pandemic. And it will be presented by the Honorable Frank P. Geraci Jr., who is our Chief Justice here in the Western District of New York. So thank you again, Jen, and I hope everyone enjoys their Thursday.